appeal Shop Direct Group and the Commissioners for Her Majesty's Revenue and Customs.
Lord Hodge will explain the decision of the court.
This appeal concerns the liability of a company for corporation tax on the repayment of a large sum which had been paid in error as value-added tax. Between 1978 and 1996, various companies in the Littlewoods Group sold goods to agents with a discount for a commission. The representative member of the group paid large sums to HM commissioners for customs and excise on the understanding, which it shared with customs and excise, that the sums were due as value-added tax on those supplies. Several years later, in 2003, after a judgment of the Court of Justice of the European Union showed that the VAT which had been paid had not been due, the group made a claim to HM Revenue and Customs for repayment of the sums which it shouldn't have paid. By this time, the various companies within the group which had made the supplies and paid the tax had permanently discontinued their businesses. In 2007, the Revenue and Customs paid large sums representing the overpaid VAT and also interest on those sums to several companies within the Littlewoods Group. HMRC then assessed the companies to corporation tax on the sums which they'd received, on the basis that the sums contributed to their profits. The companies challenged those assessments, and before this court, the only remaining challenge is that of the appellant, Shop Direct Group, which I will call SDG. SDG received £125 million, which it and other companies in the Littlewoods Group had paid years before. It also received a large sum as interest, but it did not receive permission from this court to appeal against the finding that it had to pay tax on that interest. The appeal turns on the interpretation of words in several sections of the Income and Corporation Taxes Act 1988 as amended. In short, SDG asserted that it would be liable to pay tax on money it received only if it had been the trader whose supplies had given rise to the VAT which had been paid in error. SDG also argued that it had received the funds simply as a result of an arrangement which was made within the group of companies of which it was part once it had been known that the repayment was imminent. The tax legislation required the source of repayments to be the trade which had been carried out. And SDG argued that here, the recent arrangements, and not what had happened in the more distant past, were the source of the payments to it. Other companies within the group might possibly have some liability to tax on the receipts, but, it asserted, the Revenue and Customs had selected the wrong company. In a judgment which I have written, this court rejects those submissions. The relevant tax provisions were first introduced in 1960 to prevent the loss of tax on income arising from a trade where the trader retired early or died, and he or his estate received the income after the trade had been permanently discontinued. Before 1960, what was generally called post-cessation receipts had escaped income tax altogether, and the taxpayer could choose to retire shortly before the tax was due to receive the large sum, shortly before he was due to receive large sums from his trade, which he would then receive tax-free. Many people did. Also in one case, which concerned the famous actor Leslie Howard, who was killed by enemy action in 1943, it was held that if the taxpayer died and his estate received income after his death from his prior work as a trader or a professional, no income tax was due. The Finance Act 1960 closed the loophole by bringing into the tax charge post-cessation receipts. The provisions which Parliament then introduced have been preserved in modern tax legislation. The aim of the charging section is that sums which a person received, which arose from a discontinued trade and which were not otherwise taxed, should be brought into tax. There is no policy reason for confining the charge to the former trader. Thus, if he assigned his rights to such sums to someone else for no value, that person should be taxed when he or she receives the post-cessation income. The wording of the section confirms that it is enough that someone receives the sums which have arisen from the carrying on of a trade before discontinuance. The court interprets neighbouring statutory provisions as consistent with this approach, including a provision to tax the receipts if the former trader assigned them for value. The focus in the relevant statutory provision is on the original source of the receipts, and this is not altered by the arrangements made within the group of companies that a certain company was to receive the repayment. It was not clear on the evidence led before the First-tier Tribunal why STG had been selected to receive the repayments, but that uncertainty does not matter. The VAT repayment is subject to a charge to corporation tax in the hands of STG.
Thank you. The court is now adjourned.